Thank you, everyone. I'm Alex Moss. I'm the director of the Public Interest Patent Law Institute. Very grateful to everyone who is here this Friday, both to listen and especially to our panelists who are going to tell their stories about what happens when low quality patents are used in ways that are harmful to innovation and to small businesses. These are the people that the patent system is supposed to encourage and some more support. Extremely creative, innovative, visionary folks. And so I'm really excited for them all to have the opportunity to talk directly about what's happened to them. And I want to emphasize that what's really exceptional is that they're willing to share their stories because they really are the tip of the iceberg. This happens to so many, but most people are afraid or not able because of confidential obligations to talk about what happened. So this is really a unique opportunity, and I'm extremely grateful to our panelists. I'm going to introduce them before giving each of them an opportunity to tell their story. So first, we have Austin Meyer, who is an inventor, a filmmaker, a venture capitalist, created the flight simulator X-Plane, an app, Xavion app that provides assistance to pilots in the cockpit, made a documentary, The Patent Scam, that tells a number of people's stories about their experiences with the patent system. Highly encourage you all to check out The Patent Scam if you haven't. And he's also an investor with Beta Technologies, which makes electronic aircraft. So thank you, Austin, for joining us. Next, we have Michael Lewis, who is also extremely an inventor with patents in his own name, the former CEO of Mycroft AI, which sought to make an open source, privacy-aware voice assistant that would have competed with entities like Alexa. And before joining Mycroft, Michael also co-founded the company Stellar Semiconducting and was a creator of a groundbreaking game called City of Heroes. So a innovator and creator on multiple fronts. So Michael, really glad that you are here. Also, we have KS, who is an independent videographer who creates videos for a wide range of clients, including public school districts. We are using the initials KS to protect their identity because the patent troll that went after them did so fairly recently and is still active, and want to be cautious about poking the bear. Next, we have Ricardo or Ricky Bonilla, who is a litigation attorney at Fish and Richardson in Dallas. He practices in a range of commercial and areas, but focuses on patent litigation. And I want to add specifically that Ricky has been a real hero to us and to many small businesses and individuals that have encountered patent trolls and have needed help. He's helped us help people for free. He's provided help to so many folks for free or for very, very low cost. And he's like a real hero in the patent world. So really grateful that you're here and able to talk about all the folks that you help and shed some light on the sort of business model behind patent trolling. So thank you, everyone who's here. I'm going to turn over to each of them, and then we will have questions. But as Austin's emphasized, questions are welcome as we go. There's a Q&A box, so please feel free to enter questions. And if any of you are speaking looks at that, feel free to answer. If not, I'll bring up those questions at the end when we talk to all of you again. So with that, Austin, please take over.
Awesome. Thank you so much. Okay, so first of all, as Alex indicated, please do feel free. I wish I was in the room with you guys so I could take feedback directly, but feel free. I've got the chat window open. So absolutely, in the middle of my talk, do send messages to chat if you want to interrupt and ask a question. That's absolutely fine. And then there's a Q&A window as well that I got open. So if you can figure out how to enter something in the questions, do that, and I'll be happy to answer. And that does absolutely include in the middle of my presentation. So some years ago, I think maybe it's 10 years or 15 years, probably closer to 10 years ago, I was sued by a patent troll called Unilock. And so here's what that looks like. I made a flight simulator called X-Plane. It's a flying game that you can run on your phone, and you can basically pretend you're flying an airplane. So you're sitting there moving your phone to control the yoke as the airplane flies around on the little virtual phone. And I distributed this both through the Apple store and as well through the Google Play store, so they would work on Android. And I was at a trade show in Wisconsin telling people all about airplanes, and I got a phone call from a lawyer. He's saying, "Hey, I noticed you've been sued for patent infringement. If you want, I could represent you. It'll set you back about $300,000 or so." And I was like, what? Whoa, hold the phone. I couldn't have been sued by patent infringement or for patent infringement because I've never used a patent, filed a patent, looked at a patent. I never even seen a patent at any point in my life ever. He said, "Oh, I assure you, you have been sued." And when I got home from the trade show, sure enough, the process servers is at my door at 6 o'clock in the morning. And what had happened is a company called Unilock that did not actually create any goods or services. They didn't actually make anything. They long since stopped making any sort of software at all. They just filed patent infringement lawsuits claiming that people were stealing their ideas, even though they weren't actually like doing anything. And they sued Minecraft and alongside me and about 10 other companies. And so when I got the lawsuit, the first thing that kind of raised an eyebrow is I said, why am I being sued by a company I've never heard of? How could I have stolen an idea from someone that I've never spoken to? Kind of, raised an eyebrow. And then I noticed that they were suing like 10 other companies all alongside me with the exact same lawsuit. They were just adding a whole bunch of names. And I'm thinking, well, wait a minute. These 10 or so companies that they're suing, they're all using the Google Play Store to distribute their apps. Well, if using the Google Play Store to distribute an app is against the law or stealing somebody's idea, why aren't they suing Google? Or does this mean they could sue absolutely every single person that uses the Google Play Store, which is many, many thousands of people? And then I started looking at the patent, and I saw that the patent did not actually describe how to use the Google Play Store. See, here's what the patent claimed to own. The patent claimed to own the idea of one computer accessing another to unlock software. That's it. That's what the patent owned. One computer accessing another to unlock software. Well, lo and behold, if you put your software on the Google Play Store, then when the customer buys the app, one computer is unlocking the software on the other computer. That's how online stores work. And so at that point, Unilock said that everyone that was using the Google Play Store was infringing on their patent, and they filed lawsuits against like the first 10 people, I guess they could come up with. And looking at the patent, I discovered that there was no source code in the patent. There was nothing in the patent that actually described how to use the Google Play Store or how to make one computer exchange data with another computer. They just said they own the idea of one computer exchanging data with another computer, but without actually saying how to do it. So they owned an idea that they wouldn't even describe. And then the next thing I noticed is the patent said the same thing over and over. And I'm looking at the patent now. There's I think 113 claims, as I recall. Yep, 113 claims, but every one of the 113 claims is almost exactly the same. They just changed a few words in each claim. They would say, like, for example, claim 41, a system according to claim 39, wherein the license manager is configured to verify the validity of a second verification. I mean, this is not useful information to any computer programmer or to anyone that's actually trying to build the Google Play Store or interact with the Google Play Store. It's just this vague general statement that says they own the idea of the Google Play Store, even though they had nothing to do with creating it. And so I'm looking at a patent that doesn't actually describe how to do a thing. It only says it owns the ideas of things. It's being filed by the company that does not create any goods or services, but only files patent infringement lawsuits saying their ideas were stolen, even though they're not doing any actual work. So the next thing I did is I said, okay, is this just me? Am I just unlucky here, or is this a common problem? I had a friend get me like the top 100 patent lawsuits he could find, just the most recently filed patent infringement lawsuits. And almost all of them that he found were in the Eastern District of Texas. And I said, well, that's kind of odd. Why would all the lawsuits be filed in one place? It's kind of out in the desert and not connected with any industry. And I was being sued in the Eastern District of Texas as well. There were no airliners to get there. There's a little town you couldn't get to by airliner. There were no driving would just take days to get there. Luckily, I have a little single engine propeller airplane, so I can get anywhere I want. So I landed in this little town in the middle of nowhere in my little single engine propeller airplane with the film crew. And we went to the address of every single business that was filing these patent infringement lawsuits. And every single business, without exception, was an abandoned office with a little post-it note on the door with the name of the business scrawled, by hand, or a little 8.5 by 11 piece of paper with printing like this, just sitting there, taped to the door. And there was nobody at any of these businesses. And you can see that trip yourself. If you go to YouTube, just Google the patent scam on YouTube, you'll find it. The whole thing's on film. I had a film crew film, and it's all on YouTube, so you can see it yourself. But I'm sitting there looking at my situation where I'm being sued for infringing on an idea that isn't fully described by a company that doesn't do work in a venue that represents these cases over and over and over without any actual businesses. And then the patent, what I discovered is the patent is actually, it's designed like a battleship. With a battleship, the whole idea is, boom, a torpedo takes out one watertight compartment. It's okay. It doesn't sink the ship. It's compartmentalized from the other compartments. The patent is designed the same way. It's the same claim 113 times, but every claim is almost identical. So if you go to overturn one claim, they just switch to the next claim. At this point, it was clear the patent wasn't designed to share information. The patent was designed to sue as many people as possible and be difficult to overturn so that nobody could defend themselves when they were sued. Sure enough, I did not get that lawyer that offered to try and defend me. And the 300,000 was a settlement. The $300,000 was a settlement amount that was expected. It's $3 million to do your total defense. And so I was sued alongside Minecraft and about 10 other companies. We got a lawyer that would share the fees amongst all of us. We were expecting a $3 million defense. We got out of it for about $1.2 million in defense fees. It was split 10 ways. We each down for about $120,000 in defense fees. And for that money, we overturned one sentence in the patent. About $1.2 million in several years to overturn one sentence in a patent. And that sentence basically was, a computer gets information from another computer to unlock software. And as soon as we overturned that one claim, they did exactly what I knew they would do, battleship design, right? They said, oh, you infringed claim 37. Well, now we think you're infringing on claims 75 and 42, right? One claim is overturned, just do the next two. That's why the patent was designed the way it was, to have as many claims as possible that say the same thing so you can't overturn it. And so I've been through the situation myself where I've seen the non-practicing entity, as they're politely called, filing the nonsensical patent, and I've watched maybe 3 or 4 years of my life and about 120 grand go down the toilet over this. They said they'd go away if I gave them $50,000 cash. But what I've learned from talking to other people that this has happened to is that once you give them the $50,000 to go away, they just come back with the next patent the next day, which is, obvious. How do bullies always work, right? Appeasing the bully is not the way to stop getting bullied. And it's just something I've been fortunate enough to be able to do, but to stand up to them. And I guess the final thing I want to leave you with is that my situation is just not unique. When I made a movie called The Patent Scam, and I interviewed a lot of people that this happened to. And when you look at the patent lawsuits filed in the Eastern District of Texas, none of them are from businesses that are actually doing work and then sharing an idea and trying to make sure they are paid for sharing their idea. All of them were just post-it notes on an abandoned office door used to file a patent that didn't actually describe how to do a thing, described as vaguely as possible to allow as many lawsuits as possible. So, to any congressional staffers listening, or to anyone listening, you might be thinking, well, hold the phone. I've been told that patents protect innovation. I've been told that they expose ideas that then benefit others. Okay, you've been told that. I could sit here and say, oh, that's not true, but I don't win any arguments doing that, do I? Instead, I have to let you figure this out for yourself. What are the facts? The facts are the patents don't actually have the source code. The patents don't actually describe how to do a thing. They just claim ownership of the thing. They say it as many times as possible, over and over again, so they're impossible to overturn. They're filed by companies that are not actually producing goods or services. And they're done in a venue that is as difficult to get to as possible, a little desert in the Eastern District of Texas, where the judges and their sons, the lawyers, all profit from the endeavor. So I think I'm being pretty objective here with giving the facts that I encountered along the way, and I'll take questions if anybody has them. What? No, I'm not.
I'm
Alex,
going to
you.
jump in. Yeah, I'm going to jump in with
Okay.
one, which is you mentioned overturning what sounds like a claim. Did you overturn that in district court, or was that at the Patent and Trial Appeal Board in a
It was what's called an IPR, an inter partes review. And this is what gets so interesting about this. When they said we infringed on their patent, it was obvious that their patent was predated by prior art. All right, I'll put it the clinical way. It was predated by prior art. Or in plain English, the idea was obvious. People have been doing it for years. Okay, there it is in English. What had people been doing for years? Exchanging information between computers to unlock software. People have been exchanging information between computers to unlock software for years before the patent was ever filed. The patent was absolutely nonsensical. It did not describe anything new. In fact, it didn't describe anything at all, but it didn't even claim to own anything new. It was predated by prior art. So we proved it. We did an IPR, inter partes review, and we had that claim overturned. We can only overturn one claim, which of course caused the troll to come back and say, well, what about these other two claims? And at that point, the judge said, okay, you got two more claims to file? Great, file them in the next lawsuit. And then the troll elected not to file them in the next lawsuit, because if we fought him on the first one, we'll fight him on the next two as well. And so the troll decided to go after easier targets. But I personally spent, something in the ballpark of, maybe 150 grand, $160,000, and I could have settled for 50,000. I'm going to spend another 300,000 making the documentary, but it was worth it. It was worth it to spend more money to do the right thing. But the IPR, or inter partes review, is what let me prove that the patent was silly by having it overturned. If I had not been able to do the IPR, if I had not been able to overturn the patent, then my situation would be that someone was making a ridiculous claim to own an idea that they did not own, and a patent that did not actually describe how to do a thing, filed against a person that was working by a person that is operating behind a Post-it note or a UPS box, and I would have no way to prove that the claim being made against me was nonsensical. If there was no inter partes review, I would not be able to prove that the claim against me was nonsensical. I mean, I can't put any tighter than that. Imagine you're in court and someone says, you did the following thing for some ridiculous reason, and you're not allowed to talk to the guy that's accusing you. You're not allowed to question the guy that's accusing you. Once he's accused you, it's done. There's no challenging that. That's what our system is going to be like if we overturn the inter partes review. Because once the IPR is overturned, the patent is presumed valid, and at that point, you have no way to prove that it's silly and overturn it. And if I was not allowed to question evidence against me, right, the evidence being the patent, which is presumed valid, if I was not allowed to question the evidence against me, then I'd be in a situation where I was presumed guilty and had no ability to prove that I wasn't. And I don't even know how to phrase it, what that would be like being in America and being presumed guilty, but with no right to challenge the so-called evidence that's being used against you. And what do you do at that point when the government says you're presumed guilty or the patent is presumed valid and you're not allowed to challenge it? I mean, I guess all I could say at that point is the system is being designed so that whoever files the lawsuit does not want the person he is suing to be able to overturn the patent. Put another way, how do you win a lawsuit? Make sure the other guy's not allowed to defend himself. And that's what they're trying to do now.
Thank you so much, Austin.
Yep.
And I'm just going to put a footnote, and I can add a link in the chat if anyone's interested. Unilock, the trolley mentioned, was owned by Fortress, which was owned by SoftBank, which is a Japanese company. And Fortress continues to fund a lot of patent litigation. Maybe Ricky will talk about that later. But Michael, would love to hear about your experience, different aspects of the patent system.
Yeah, thank you. So I had not actually heard Austin's story before, and you might have seen me nodding along as he was talking because a lot of my experiences were very, very similar. However, my background is a little bit different. I founded my first company right out of undergrad and immediately started getting involved in the patent system. We started looking at getting patents for our inventions. And I became over the years very, very familiar with the patent system. I've been granted over 20 patents myself. They're primarily in computer semiconductors, and although I have some in other areas as well. I've actually been an expert witness on behalf of one of my patents when some big tech giants got involved in fighting over, the things that they normally do. So I got to spend a couple of days being an expert witness and going through depositions and stuff like that, which was fun. They ended up just trading patents and licenses and stuff like they do, but that was an experience. I have been hit up by patent trolls more than once, and I've had vastly different experiences each time. So I can get into that a little bit, but really primarily, I wanted to talk about my most recent experience involving Mycroft. But I have so much I want to say on this topic, from the philosophy of patents, like they're in the Constitution. It's a really important part of our society. And then all the way down to like, but practically how are they actually used today? So you know what? In fact, I will just touch briefly on my experience with patents there, because when I was starting out, I came up through a business incubator at my college, and basically what I learned is that patents have a bunch of utility for startup companies, and one of those is in the valuation of your company and trying to raise money. One of the ways that venture capitalists will evaluate your company is how many patents do you have, and there's just really simple formulas sometimes that are like, well, it's back, this was 30 years ago for me. It was $1 million per patent, for a startup company kind of thing. So there was a reason to just even have a lot of patents. So there were reasons other than trying to protect your invention to get a patent, even back then. But jumping forward to Mycroft. So it was about, I guess it was about 4 years ago now. I started to get involved with a company that had already been around for a few years, and they were developing a open source voice assistant that you could just talk to, and it would issue commands, do things like tell you the time, set timers, look up information on the internet, play games and all kinds of things, just like the Alexa or Google Home things do. But the key to this system was that, one, it was completely open source. You could look at every line of source code, every circuit diagram, even like the plastic injection mold blueprints, so to see how everything was made for this system. And the reason that was important is that this system was intended to be completely privacy respecting. The idea was that this technology is going to be everywhere, and it can be really creepy. It's listening to you all the time in your house, and they wanted to create a system that they could prove wasn't listening to you, right? And so in order to do that, they made the system completely open. You could look at any part of it and see what it was doing. This was an idea that really resonated with me, so I started talking with the CEO about coming on board and helping out. And just as I was getting involved in those discussions, they got a demand letter from an attorney saying, hey, we've got this patent, we'd like to talk to you about licensing it. Now, the demand letter was very vague, and it turned out the patent hadn't actually issued yet. But nevertheless, they were demanding, that Mycroft infringed on this patent. So, the CEO at the time, looked into it and found out that they hadn't looked at anything in particular about Mycroft. They didn't say what infringed. And what was weird about that is that, like I said, Mycroft was completely open source. They could have just pointed at a line of code and said, this right here infringes. But they didn't do that. They just said, let's talk about licensing. So he being an Air Force major, decided that he wasn't going to have any of this BS, and he just instead posted their demand letter on the company blog with a strongly worded response, public response saying, look, this is a bunch of BS. This patent is bogus. We're not going to pay these people a dime. And so he did that to send a signal not only to the to this what we eventually did decide was a patent troll, but also as a signal to our community that as Austin said, if you if you give in to the bully once, they're just going to keep coming back to you, right? And as we found out over time, this company did have an intent to file dozens of patents related, all based on this one patent. And so his idea was like, we'll just punch the shark in the nose, make it go away, and then that will be the thing that best protects us and our community. So their response was a little bit interesting, with not my experience in previous patent troll cases. They actually decided to file a lawsuit demanding something, I forgot what it was, like millions of dollars. Okay, so now the company is faced with a choice of paying millions of dollars in license fees to this company, or spending millions of dollars defending a patent lawsuit, which is what we were told it was going to cost us. And so we opted for the third choice, which was to file an IPR and invalidate their patent. We also opted for a fourth choice, which is in Missouri. It turns out they have an anti-patent troll law, which no one's ever tested, so we decided to try that. That's all on pause right now, so who knows what's going to happen with that. But we opted for the IPR because it was merely hundreds of thousands of dollars and not millions of dollars. And it turns out we were successful. We invalidated dozens of claims every single claim that was asserted against us was invalid. There were dozens and dozens of claims. And so that was, I think, a really important tool to be available to our company. And so, the behavior of this company, I haven't even touched on. I touched very briefly on the fact that they didn't do any homework, but but I would like to kind of put that in the context of sort of the asymmetry of these non-practicing entities and these patent trolls versus businesses, and that it costs relatively little for a small group of lawyers who want to go out and file a bunch of patents. It's a bit of their time. They don't have to charge themselves $400 an hour or whatever to go out and file patents. And which is what this was. The people who owned this patent was a group of about 4 attorneys who actually had a prior business relationship with the patent attorney who prosecuted it for them, and all kinds of really shady stuff was going on there. But let's see. Sorry, where was I? I get all wrapped up in this. Sorry.
Yeah. He had just posted the response, and he had just posted the response online, and the troll was like, "Oh, I'm going to show them. And then they come back to their lawsuit with the greater demands.
Yeah. Well, exactly. Oh, right. Yeah. So the asymmetry, right? Thank you very much. So it costs them relatively little to, file the patent. It's about $20,000 to procure a patent around these days. For somebody like me, for them, it's just, probably, I don't know, a couple dozen hours of their time. And so they can impose a demand on small businesses by sending out these demand letters, by the dozens or hundreds, and just hope that one of them will bite and give them $30,000, $40,000, $50,000. And they don't need very many of those to get to break even and then profitability. And then the game plan from there is that then they take these things where someone's paid them a license fee, and they go to a big tech giant like Apple or Google or somebody, and they say, hey, look, we've got a valid patent. People are paying us money for it. Give us millions of dollars, right? And then those tech giants have various policies on whether they fight them or pay them off or whatever. And so that's kind of the game plan there. And there's a huge asymmetry, right? Because the cost for me to defend myself, just calling up a patent attorney and saying, hey, what's it going to cost to defend myself? Most of them will do a free consultation, but they'll just tell you it's going to cost millions of dollars. But, going any further than that, the costs go up very, very quickly. So in general, it's just better to pay the $30,000, $40,000, $50,000, but like Austin, we were people of principle. We were like, I in particular was in a position that I've been successful in the past with some of my businesses, and I'm like, no, let's stand on our principle. Let's fight this. This is ridiculous. This system shouldn't be abused like this. And so it cost us, I was willing to pay the hundreds of thousands of dollars to stand up to that and send that signal. But if we didn't have that IPR process, obviously that wouldn't be possible. Now you're going to get, on the other side, people are going to be complaining that, like, oh, well, but somebody can just, if I've got a valid patent and I'm asserting it against somebody, they can just spend, they can just spend a little bit of money instead of paying my license fees to invalidate my patent. And now I have to pay attorneys to fight to defend myself against, against these people who are trying to invalidate my patent. But again, the system is asymmetrical, because to file an IPR costs more for the person who's filing the IPR than it costs to defend it, because there are statutory government fees to even start the IPR process, which just adds on to the cost of paying for the lawyers. So if you wanted to actually file an IPR, you have to be serious, because it's going to cost you a minimum $100,000 just to get the ball rolling, right? Whereas filing an actual patent, even especially a bogus patent, can cost you $10,000 or $20,000. So there's a lot of asymmetries in the system, and I don't think that changing the IPR process right now is going to benefit anybody. I was actually talking to Alex. This is my last little side note here, that
it'll benefit people. If there's no IPR, it'll benefit people. It'll benefit the people that file the patents that don't want anybody to be able to challenge what they say. It'll help the people that don't want to have to actually defend what they're saying.
Yeah. Well, right. It will benefit trolls. But I was also saying to Alex, like, if I were an adversarial state actor trying to mess with the United States economy, I would have a hard time coming up with a better, really sneaky way of doing it than this Prevail Act. Like, it's going to have consequences that people don't really understand. So anyway, I'm also happy to take any questions. Thanks.
We're going to come back with questions. I'm going to make sure to turn over to Ricky. And I know you work with a lot of different folks in this type of situation. I'd love to hear kind of your experience with patent trolls. I know there's some people saying, well, they're not really a thing, or they're not so prevalent anymore. And so I'd love to hear what your experience like is, on a day-to-day basis.
Thanks, Alex, and thanks, Austin and Michael and KS, for sharing your stories. I am Ricky Bonilla. I'm a Dallas litigator, IP litigator here in the Dallas office of Fish and Richardson. And since I am in Dallas, Texas, I do feel the responsibility to respond to Austin's reference. The Eastern District of Texas as a desert, that is the green part of Texas. I just want to be clear, but it is desert-like. The first thing I'm going to say might be something you're not expecting me to say, which is patents are good. They are good. The patent system, however, can and is abused every single day. And it is set up such that if you have a patent, we all know patent infringement is strict liability. Doesn't matter if you knew about it, doesn't matter if you don't think you infringed, doesn't matter if you have whatever argument you have. Once someone has a patent and pays the $400 fee to file a lawsuit in court, you are now on the hook and have to respond. And responding to a patent lawsuit is incredibly expensive. On the low end, it's $3.5 million just to get through a patent lawsuit. It's $350,000 just to get through an IPR. And when you've got someone who's saying, I want $35,000, we're talking about orders of magnitude in difference, right? And I went to law school because I wanted to be a patent prosecutor, actually. I wanted to help people get patents. And then my first year as a summer associate here at Fish, I was working on a case on a litigation matter for a patentee, against a patentee called Geotag. And some of you may have heard about this because Geotag filed over 450 lawsuits in the Eastern District of Texas asserting a single patent. That patent, the patent itself, was directed to bird watching. It was a system where if I was out bird watching with you, a friend of mine, and I saw a bluebird, I could type into the system, hey, there's a bluebird over here. And that person could then, my friend, you would go and say, oh, there it is. Geotag took that patent, the bird watching patent, asserted it over 450 times against almost anyone who had a website with a locator service. So if you're looking for a restaurant, if you're looking for a shopping center, if you're looking for anything and you click locations and it gives you directions, you are a target. Now, geotag ultimately lost its patent and lost its lawsuits, but that was after years of litigation and after dozens and hundreds of companies paid them a license. And when I found out that that was happening, I thought, no, I'd rather work in litigation. And so the bulk of my work over the last decade has been in defending against these kinds of lawsuits. And they're not slowing down. What's happening actually is we're seeing fewer, less sophisticated opposing counsel or patents or patentees, but instead of filing lawsuits, now they're sending demand letters. And those are things that people don't see, right? They send a demand letter and say, pay us $35,000 or we're going to file a lawsuit. And remember, the defenses are IPR, 350K, or full defense, 3.5 million, 10X, 100X. Well, some of these companies, these small businesses especially, $35,000 might be their life savings, but they don't know any better. They don't know to go and reach out for counsel. They don't know to reach out to the Electronic Frontier Foundation or like Austin did and start doing some searching and looking on their own. They don't know to do those things. Instead, they end up cutting a check. And what happens when you cut a check to these particular NPEs? They darken your door 2 months later with another patent asserted against the same technology. So this happens over and over and over again. And I've been fortunate to be working with Alex to get to know some of these folks before they pay the NPE to try to help them out. And the way that I help them out is either by grouping folks together so that we can split costs, the way that Austin mentioned. I mean, $120,000 is not a small amount of money, but it's better than 1.2 that he would have paid on his own without these other 9 defendants. So I will group folks together so that they can afford the fees, the fish charges for my time, and we can put together a meritorious defense. And IPR is a really big part of that, but so are eligibility contentions. I know that that is something that is a hotbed at the moment. A hot issue is what we do with patent eligibility. Well, you really shouldn't have the ability to patent the idea of bird watching using a computer, right? Back then, though, there was no Alice decision from the Supreme Court. 101 didn't have the teeth that it eventually came to have, even though those teeth have been filed down a little bit in the last few years. So you get these constant campaigns where people are receiving letters and not knowing what to do. And it's affecting their business. It's actually depressing business. It's not stimulating innovation. It's being, like I said, the patent system is being abused such that you end up in a situation where, for example, KS, his business isn't what it used to be because he got targeted by this individual who started going after public schools. I mean, these are the kinds of stories that we really don't want to hear about. And you don't hear about because they don't go to court. Now, when they do go to court, how are we supposed to defend ourselves? How am I supposed to represent my clients? Right? IPR is an option, but it's still not cheap, right? To go from the beginning to the end of an IPR on average is 350 grand. That's also a lot of money just to file, just the statutory fees. I think Alex put it in the chat. The statutory fees are tens of thousands of dollars just to file a petition. And all of that has to be put up against what the patentee is demanding, which can be as low as $10,000, $15,000, $20,000. That might not be anything to big major companies and tech companies, but it's a lot to these small businesses. And so it's important for us to have the ability to defend ourselves, to challenge at the outset whether the patent that you have is really meriting of having been issued. Because examiners, they have plenty of work to do. As we heard from Michael, it sounds like eventually someone just said, you know what, just give them the patent, like make them go away. We're not dealing with this person anymore, right? Well, once that patent is issued though, now it's presumed valid as Austin mentioned, and we have to fight against that. IPR helps. Eligibility challenges early in a case at Rule 12 on the pleadings are very helpful because you can prepare a motion under 101 that can be ruled on early in the case before discovery, before you spend all of this money, all this time, all these resources, before you significantly disrupt somebody's business. You can do that early on and on the pleadings. And if we dismantle that, what you're left with is if someone is just able to get a patent, all they have to do is sue you in the right court. And as long as they do that, you have to now defend yourself. Full defense. by the time I get to a point where I can file a motion for summary judgment even, so I'm not even talking about trial, even that can be millions of dollars in going through discovery and preparing to challenge a patent that probably shouldn't have issued in the first place. Or even if it did issue, it should not be asserted in the way it's being asserted. The geotag case, for example. And the other issue is that these individuals, these entities, they don't sue the vendors. They don't go after who's providing the technology. They go after who's using the technology. Because if you sue the vendor, that's one check you're going to get. But if you sue every single customer, that can be hundreds of checks that you get. And then once you've exhausted that, now you can go back to the vendor and try and go after them at that point. And as an example, I had a case that I'm defending right now, where I'm talking to opposing counsel, and they had agreed to a license deal, a settlement agreement with a vendor that they did not know this vendor had so many customers. So they agreed to a small number. Well, now I'm representing some other customers that don't work with that particular vendor, so other clients. And I'm saying, look, these clients shouldn't have to pay as much as that vendor did, and that vendor only paid a 5-figure sum. And the response from opposing counsel was, oh, well, we didn't realize they had so many customers. We are not going to make that mistake again. So it's not as if they learned their lesson. They don't even they're not even consistent within what they've been doing in the past. All they want to do is file a lawsuit and then leverage the cost of defense against anyone they file these lawsuits against and say, look, it's going to cost you a lot less money if you just pay me what I'm asking for than if we go through this whole process. And it's fortunately we have people who are principled, like the 3 individuals you just heard from, that are going to fight back because they know if you just pay them, if you open up that checkbook, they're going to show up again. The other thing I keep saying is they. Who is they? Well, they go through a lot of effort to make sure we don't find that information out. Some of you may know what's been going on in the District of Delaware, where Judge Connolly has been asking questions of multiple patent assertion entities, where it turns out that the people who are the managing principals don't know the patent, never spoke to the attorneys. All they did was somebody came up to them and said, hey, how would you like to earn some passive income? And they signed a piece of paper that said they are now the managing principal. But it turns out they don't know anything about it. They make very little money from it. Almost all the money goes to the attorneys that set this structure up. And what's worse is if I'm able to defend a client and we're successful in getting the court to reach the merits, to agree with our side, to invalidate the patent, and then to shift fees and say, all right, Ricky, your clients are the ones who shouldn't have been sued in the first place. This was frivolous. So we're going to make the plaintiff pay. You know who's on the hook for that? Not the attorneys that set the structure up. It's that person that was asked about passive income. Another potentially small business owner. One of Judge Connolly's opinions, he questioned an individual who said, I quote, I run a fried chicken joint. He's not going to have the money to pay for fees that they get shifted, but all the liability goes to them. All the benefits go to the individuals who are abusing and taking advantage of the system. And so what we need to respond to that is some tools so that at least some of the clients, some folks can have the ability to fight back early and not have to spend millions of dollars litigating over what are patents that maybe shouldn't have issued in the first place.
And Ricky, I'm going to hop in with a question. Somebody asked if there were certain industries or technologies that are more vulnerable to patent assertion entities. And sort of, I'm going to kind of tag on to that. What's the range of, folks that you've represented? Because I think, I know there was one company that sold brownies that you helped, but I'm curious if if you think some are more vulnerable, but also kind of like, can you give us examples of the range of folks that have been in the situation?
Yeah, so I'll answer both questions. The first question I think was the technologies. If you have a website, you are vulnerable to attack by a patent troll. Because there are so many patents that have issued that talk about basically just client server architecture and in different ways, but basically the same idea. And so if you've got a website, they can point to it. If there's any modicum of personalization to your website, that's another venue they can attack by. If you have a mobile application, they can attack that as well. It's become more and more ubiquitous as people, as entities, as small businesses have gotten more access to technology. the patent assertion has gotten broader as well. It's not limited to any one particular field, right? And as far as my range of clients, yeah, Fish represents the Samsungs and Apples and Googles of the world, but a lot of the clients that I have are much smaller. The one that Alex mentioned was a sole proprietorship that sells brownies online. They are fantastic brownies. If anyone ever wants to place an order with them, I get them every year and my family loves them. But all they did was set up a website to sell their brownies, and they got two demand letters from two different entities, right? Two different entities who contend that they have two different patents directed to the same thing. And both letters looked very similar. It turns out that it's because the ultimate principle was the same, just working through different patent assertion entities. But what we ended up doing was we prepared a letter for them to respond to these demand letters. And what happens when we do that? We send them a letter that says, look, your allegations are frivolous or they're meritless. Here's why. Here's case law showing that your claims are invalid. Here's how they are just like other claims that have been invalidated. If you continue down this path, then we have to make a threat, right? If you continue down this path, we will defend ourselves to the full extent possible, including seeking our fees. And we've been successful in doing that. And what do the patentees do? They don't respond. They move on to other targets. They just file, they send letters to other entities, to other people, hoping that they don't call me, hoping that those individuals that receive those letters don't reach out and find out, oh, there's a way to fight back. There's a way to push back. Or hoping that they decide, you know what, I don't want to spend the money that it would take to respond to this. I'd rather just pay the settlement. And then they're targeted later again.
I'm interrupting because I want to ask, this is a good question that I know you know the answer to better than anyone. Who are the lawyers on the other side? Can you tell us about the lawyers? And maybe also, can you tell us, like, who are the principals and entities, and how are you able to find out if you're able to find out?
So we're not always able to find out, but the example that I'll give is just what's been going on in Delaware with Judge Connolly, because it's all public, and so this isn't confidential. But the individuals in the Delaware situation, it's 3 lawyers. They used to be patent litigators. They started a company called IP Edge. And IP Edge has several subsidiaries, one of which is Mavixar. And so what IP Edge does is they work with Mavixar. It's the same attorneys, just 2 different entities. Mavixar is the consultant that finds these people for passive income opportunities, signs them up as the managing principal of an entity. They create this new entity. They transfer some patent they've received, however it is they've obtained it, into that entity. They file the lawsuit. They handle absolutely everything having to do with the case. And whenever there's a settlement, they take 5% of that and they send it to Mr. or Mrs. Passive Income. So the lawyers that we're talking about are people who used to be litigators. Some of them used to work in big law firms. And I don't want to name folks by name just because I think that'd be uncouth, but you can find out who they are very easily. IP Edge, for example, has a website. You can see the 3 people on their website. And here's the thing. I think, me personally, that a lot of this is nefarious and it is an abuse, but sometimes it's not. Honestly, sometimes it's people just taking advantage of the system as it's set up. What they're doing is not necessarily illegal. Now, sometimes it has been, I think. But what they're doing generally, asserting a patent, it's not illegal. Asserting a patent in a broad manner is not illegal, right? So they can do what they're doing. So the defendants should be able to do what they're doing, which is defending themselves at the outset of litigation, at the outset of a matter, before the parties, courts, and administrative bodies waste a ton of resources dealing with patents that really, in the first place, shouldn't have issued.
Wonderful. I'm gonna have an answer, but somebody asked if the PTO is issuing fewer of these patents now and benefiting from the new KSR expertise. And honestly, the answer is, it seemed like it was going to issue fewer patents. The Supreme Court issued a decision in 2014 in Alice v. CLS Bank that said, doing something basic, sending information between 2 entities, isn't patentable even if you add a generic computer to it, because a lot of the arguments for this was, these aren't abstract ideas because, see, there's a computer. And the PTO issued new guidance. There were grounds for optimism. And frankly, the former director, Andre Yanku, issued new guidance to the examination corps that fundamentally changed the way they were applying it and effectively prevented the examiners, from applying the Alice decision. They're now granting patents if there is, on an abstract idea, if there's any practical application, i.e. if there's a computer. So unfortunately, after a sort of brief but promising period, it seems that the PTO is issuing more of these patents. And I've heard from examiners anonymously, in fact, that their access to case law was taken away. I don't know if it's been restored under this director, but so as a result, they're not able to use case law. They are restricted to using the PTO's guidance, which is not consistent with the law. And the Federal Circuit has even said in some of its decisions that the PTO's guidance is not consistent with the law, and therefore is meaningless to their decisions about patents. But I also want to turn to one topic, which is, I think, important to come, that comes up, is people sometimes ask about how all this affects investment. And like Michael, I want to, something I know you dealt with, and curious if you can talk about the way that the allegations of patent infringement and having that suit pending during the IPR, how that affected investors and Mycroft specifically.
Yeah, sure. I will just add real quickly that that is the kind of patent that was asserted against Mycroft. It was about using a computer basically to talk to another computer and give it commands via voice that would then run a program. Like it was literally just computers talking to each other, doing a thing that they could already do. It was exactly that kind of patent that was asserted against us and invalidated. With respect to investment, yeah, when I came on board, in retrospect, the company was doomed from the start. From the moment that patent demand letter was issued, Mycroft was doomed, and that was because, if you think about it from a venture capital point of view, getting someone to invest hundreds of thousands or millions of dollars into a business, they literally get thousands of applications for every one that they issue, right? And for every investment that they make, and so most of those are probably not worthy of investment, but I think a far more are worthy of investment than they actually are able to invest in. But if you go to them and you say, well, I've got this bogus patent, asserted against me, you just go right to the discard pile. There's no reason for them to invest in your company with that element of risk hanging over you. They've got 99 or 900 other choices to look at. So that alone is a huge impediment to investment. So yeah, I mean, there was basically no way, even though I came on board having sold my previous companies for a total of over $200 million. That wasn't all my money, unfortunately. We had lots of investors and stuff, but I had been very successful in developing technology in the past, and I had a good track record. I should have been able to raise money for this company, and I absolutely was not. I mean, I had investor after investor tell me, wow, this is amazing. Your argument is great. These things are creepy in my house. My spouse doesn't like it. I really would love to have this in my house, but I can't invest in your company. And, that was the end of the conversation. So, yeah. I mean, as you guys were talking, I made some notes, and so many of the things I don't know. So many other of the things that people said, I recalled, like, oh yeah, that was exactly us. Our patent was originally asserted against us in the Eastern District of Texas, which is illegal. The Supreme Court has ruled you're not allowed to do that, unless you actually have a standing there or whatever it's called. But they did it anyway because it was easy, and there's a better chance that they'll just get paid. When we pointed out that it was illegal, they dismissed it and then voluntarily and just moved their case to Missouri. But that's just an example of how the system is being abused. Our case was actually dismissed in Missouri because they didn't bother citing any claims. like the judge just threw their case out and said, you didn't do any of the stuff you're supposed to do in asserting a patent against somebody. But here's how you can do that, and gave them a nice outline on how they could fix their lawsuit against us. And so they just refiled it with all the problems addressed, you know. If you go to somebody and say, hey, give me money or I'm going to sue you, or give me money or give me your lunch money or I'm going to beat you up, you know, this is extortion, right? And I know that a lot of what attorneys do can be sort of classified as, it looks like extortion. I actually talked to a lawyer about this and he laughed at me. He's like, of course, that's my job. My job is to extort people for money. But in this particular case, when you take a patent and you have on a thing that you have absolutely no intent on ever building yourself, right? And which, you know, as Austin pointed out and Ricardo pointed out, they don't actually describe a thing that's actually being built. They don't actually, there's no way to take this patent and turn it into something useful. It does not describe an invention anymore. Like the whole point of a patent is that it has to teach the public how to build a thing. This is the contract between the government and the people. It's that we're going to give you an exclusive license, but you have to teach us how this really cool thing works. If the patent doesn't teach anything, then it's completely useless and it's an abuse of the system. And so these kinds of patents have become not a way to protect your invention, but a way to get a license to sue people. And more patents are just being used for that. Yeah. So, you know, you look at the tech giants, they have so many patents. But guess what they do with a lot of their patents? They pool them together and promise not to sue each other because they know how ridiculous it is and how much they depend on each other for all of these, you know, different technologies. And so you get the big companies, they don't, you know, unless they get into headbutting over some other thing, you know, they generally don't, you know, sue each other over these kinds of ridiculous things that all these NPEs are doing. And on the question of eligibility, 2 patents were asserted against Mycroft. Unbeknownst to us, another company actually got wind of this via a news article and filed an IPR on one of those patents because they thought it was so ridiculous. And so when we went to file our own IPR, we were like, oh, wait a second, someone's already filed an IPR against one of these patents. Great, they saved us half our costs. So if they didn't have the ability to do that, even though they weren't the ones being sued, that would have cost us, you know, hundreds of thousands of dollars more, you know? Let's see. Oh, and the IPR is limited in how many claims you can challenge because of the word count. So a patent can have a gazillion claims. And so every patent that's asserted against you might need to have more than one IPR filed in order to challenge that patent properly. And that's actually what happened to us. There were so many claims in the patent asserted against us that we could only address the ones that were the claims that were asserted against us. There were still like a dozen claims left in that patent that we could have easily challenged because, as I forgot who was saying it, but they were just cut and paste copies of each other. I think it was Austin saying it. There's, you know, all the claims are just cut and paste with a word changed, you know. But we couldn't challenge all of them because we just ran out of words in the word count limited, you know, response for the IPR. And so we had to leave those as being, you know, the patent is granted, you know, with those being the only claims, which, you know, is another, you know, way that the IPR process, even though it's good, is still limited, you know. Yeah. Oh, and the patent asserted against us took 10 years to get granted, 1,000 pages of documentation back and forth. The patent examiners clearly just got exhausted. They issued a ruling saying, okay, we're going to allow it with these narrow definitions, and then, okay, we're going to grant you your patent. But those narrow definitions don't become part of the patent. So then the person who owns it can then go off and just assert the patent without just completely ignoring those narrow restrictions because it's not in the patent itself, right? It's just in these 1,000 pages of documentation that no one's going to bother looking at until you get into the millions of dollars of lawsuits. So, yeah. Anyway, sorry, I just had to jump in with all those.
Very appreciate that. And I know Austin also, since you also do Oh, well, I'm going to jump in. A question asked, is there utility in the other administrative challenges, like ex parte re-exam or PGR? Actually, this is a really good question. I was thinking of maybe asking Ricky. I know, you're aware that PGR is available only in the 9 months after a patent issues. How useful is that to challenge a patent during the 9 months immediately after its issuance? Is that equivalent to IPR? How useful is that process? And we'll talk afterwards about ex parte re-exam.
Not very useful unless you can sit around and just see every single patent that gets issued or every patent application once it gets published 18 months after filing. Unless you know about it. And like I said earlier, it's a strict liability situation. Doesn't matter whether you knew or not. So unless you know that the patent's out there, it's not going to be all that helpful. And these other administrative challenges, there is utility, but it's not the same help that an IPR can be, right? It's not the same help that actually going in front of 3 administrative law judges to see if the examiner's work here needs a closer look, right? Those are of such extremely limited utility that I have been doing this work for over 10 years. I've never filed either one of those. It's just not as helpful as directly challenging the patent, either via eligibility or other patentability issues at the district court or via prior art assertions at the PTAB.
And thank you for that. I just had put a link to the USPTO's Patent Gazette. If you wanted to check out every patent that was issued, that's where you'd look. And as you may know, they list the patents by technology classification area, but they don't actually list like the titles. And it's quite a difficult publication to read through. Now, Ricky, and KS, the patent you talked about had been subject to an ex parte re-exam. So an ex parte re-exam allows anyone to ask the PTO to look again at the patent, and it effectively goes back to a patent examiner. I don't know if it has to be the same one or not, but it's effectively a continued examination. The person or entity requesting it submits prior art. The examiner looks at that prior art and makes a decision. And the patent owner then has an opportunity to respond to the prior art as well as to amend their claims. There is no opportunity for the requester to participate, hence the ex parte name. And as happened in Kansas case, the initial patent was fully canceled and the amended claims were issued, and of course they could still be asserted no matter what they actually said. And I guess, yeah, Ricky, can you weigh in at all on sort of to what extent does ex parte come up as an option, and what your take on it is in terms of its utility?
I mean, a good example is kind of what happened to KS here, because even though this patent went through re-exam and multiple cancellations, it eventually issued with more claims. And the individual behind this entity, he started putting in his letters, see, I have all these claims, this patent is valid. And it's even more valid because it's been challenged all these times. Now, it might be a little bit counterintuitive. There have been situations where judges have said, look, if it took that long for it to overcome challenges, then it seems like there's a problem here. But that doesn't stop the patentee, right? It doesn't stop them from sending more letters to KS and reaching out to his clients and saying, every time somebody tries to challenge me, they've lost. You got to pay. And a lot of times they do when they shouldn't have to.
And I'm gonna turn to also the question, but first I do want to ask Ricky one thing, which I think might be worth noting. We talked about Texas a lot, and then you talked about Judge Connolly, and basically what's aside from Texas, where would you say most patent cases are litigated?
So today it's the Western District of Texas, or the Eastern District of Texas.
Outside of Texas.
Oh, outside of Texas. Outside of Texas, I mean, Delaware is a place where there are a lot of patent litigation because of, I think somebody mentioned, the Supreme Court, I think it was Michael, mentioned the Supreme Court's decision in TC Heartland, where you can only sue somebody, a defendant, where the defendant resides, which means where they're incorporated, and most companies in this country are incorporated in Delaware, or where they have a permanent and real location or principal, a place of business. And So there's a lot of lawsuits that are filed in Delaware, but now, because of TC Heartland, what we're also getting is lawsuits being filed in front of judges who've never handled a patent case before. Like I had a case in the Southern District of Florida, and the judge started our hearing by saying, clerk and I, this is our first patent case, so you got to take it slow, counsel. Cases that are filed now in Wisconsin, in the Western District of Virginia, in the Eastern District of Tennessee, these jurisdictions that don't have local patent rules like Texas or Delaware or California, that don't have patent savvy judges or law clerks, it's just more opportunity for the patentees to take advantage because they can get deeper into cases with a jurist that really has to get caught up on patent law before they can even look at the case they're trying to deal with, not to mention the rest of their docket. So there are places that are still kind of hotbeds, but there are also, places that don't have that sophistication that are also getting lawsuits and only making it more difficult for defendants to defend themselves.
Thanks. And I appreciate that. And Austin, one thing you mentioned, you're also sort of an investor, and I know, curious, like if you have thoughts also about how the PTAB or how patent eligibility might affect people thinking about investing, especially like in the international context, like how it affects U.S. companies.
Oh yeah. Oh, I know. I've invested in companies, and I've had my companies invested in, and so I absolutely see this all the time. And to kind of almost seemingly oversimplify but not simplify, watch Shark Tank. Like literally, that's all you got to do. Watch Shark Tank, and then they're asking the same thing the inventors every time. Do you have patents? And they're like, oh, I have a patent. Oh, I guess it's a safe bet then. And so yes, people absolutely do use patents to raise venture capital. I guess Mike was saying it's $1 million a pop or something like that. What I know, having seen patents and seen investing and done investing, it's nothing but just a little shell game to say, look, I got a thing. Well, okay, I can't be bothered to look at the thing, but I guess that's $1 million. It's just people looking for an excuse to justify making an investment, or just people giving themselves a little security blanket. But it's just one of those things. I've actually spoken to a patent lawyer that's involved in this neck deep. And I said, but these patents, they could easily be overturned if it ever came down to it. And the real value is in the people in the company, not the patents they file, and the actual work and goods and services that are created, not the paperwork that's generated. And the patent attorney, literally to my face, he just goes, yeah, I know, but if you want to play the game, that's how you play the game. So yeah, we do use patents to increase company value, but it's just a game. And let me say, just I've never filed a patent and I never will. I'm anti-patent, and I think the whole system should be thrown out. This has been such an abused mess. I see every patent I've ever seen should be overturned like that. It's used for extortionate purposes. And when you look at the patents that Apple Computer files, for example, how many of Apple Computer's patents actually have the source code to Apple's operating system? 0. How many actually have all the schematics and design and systems for the phone and relationships, people in China that are actually building their phone? 0. There's no useful information in the patents. The actual useful information is always kept secret. The patents are not used to actually help others by disclosing ideas. So I disagree with Ricardo. I say the whole patent system should just be abolished, because when you look at how it's not used to protect your rights. If you want to protect your intellectual property, how do you protect your intellectual property? Don't tell anybody. This is why Apple doesn't have open source code. They keep their source code private. And if you want to see what the value of a company is, it's not the paperwork they generate, it's the goods and services and the people that know how to generate it. So patents are used to raise venture capital, but that's just a failure in venture capital.
My follow-up will be, I guess, what would you say to folks who think that, compared to companies in Europe or in China, that if you have the PTAB or you have limits on patent eligibility, that U.S. companies are in an unfair or at a disadvantage compared to other places? Like how does the PTAB put U.S. companies at a disadvantage?
Right. So I have 2 answers to that. So first of all, the United States patent system affects other countries much more than you might think. In the lawsuit that that was filed against me for patent infringement, they also named tons of companies over in Europe. Minecraft was sued. The Mojang, the guys that made Minecraft, were sued right alongside me, and they were out in Norway or Sweden or someplace like that. And then there were some companies in like England that were sued as well. So first of all, let me say our patent system is damaging companies outside of the United States as well. It's more of a global scourge as I've seen myself. Now, that said, Mike Lewis was absolutely hinting at something huge when he said, you know, if you're a foreign actor, this is a pretty nice way you found to tie everybody's shoelaces together in the United States. And indeed, as you told me, Alex, on the phone maybe a few days ago, and I actually didn't know this before, but I think you also mentioned during this meeting, a Japanese company owns a trolling company called Fortress that then files lawsuits that are then used most likely against American companies. And whenever there's a patent lawsuit, it's just tying the shoelaces together of the business. And that's really putting it politely, of course. They can't move forwards. Maybe they can't raise money, although, you know, bring me the world's smallest violin. Nobody's entitled, you know, by some sort of, you know, fact of nature that they're allowed to raise all the money they want, right? But maybe they aren't able to work with a customer. This is what KS is seeing. He can't go to a customer without the customer coming to him the next month going, hey man, you got me sued, you're out of here. And then people like Mike and myself, who have both been through cases where the defense fees far exceed the amount of money they're asking. Although the average amount the patent trolls ask is apparently $300,000, or at least it was when I researched it. And that's not exactly chump change. So I guess the question was, is this something that's going to damage the American economy? I think is kind of what you were getting at. Is the patent system possibly operated by foreign actors going to be something that's going to damage the American economy? The answer is, well, you're going to stop a business burying them in paperwork that I would view as extortionate. Does that slow you down? I mean, we got people on this call that have been just stopped by this. People that say, that's it, I can't do business. I got to retire. I can't do this anymore. So I think that answers the question.
Thank you. I'm going to close her up, but I do want to maybe just turn to Ricky and ask just sort of one question that, you know, you mentioned briefly that I think is maybe worth, highlighting as you talked about, you know, patents are presumed valid and you have that in district court. And so maybe just, you know, shedding a little light on what is different about the PTAB from district court, and you know, is it sort of just the same as district court, or are there meaningful differences?
There's certainly meaningful differences. I mean, putting forward an obviousness argument or even an anticipatory reference argument in front of a district court, in front of a jury that may not have, you know, that doesn't have the same technical background is a very much uphill battle. At the PTAB, you have 3 administrative law judges who have expertise in the field, who have expertise with patent law, that understand, you know, what is patentable, what is not, how do you apply these laws, how do you apply a reference against claims. And by the way, it's a sure shot, you know, it's not a rifle shot that you know is going to hit, right? It's no matter what, you still have to prove that the claims are unpatentable at the PTAB or the district court. The main difference is in the district court, the burden of proof on defendants for invalidity is clear and convincing evidence, which is, you know, one step below beyond reasonable doubt. At the patent office or the PTAB, it's beyond preponderance of the evidence, so more likely than not. So it's a lower standard, which is why we can say that IPR is more cost effective, because what you need is just the printed material and the arguments supported potentially by expert testimony, and the ALJs can figure out, okay, which claims are valid and which ones are not. If that burden were to change, and I know that's one of the proposals that's floating around, if the burden at the PTAB were to go up to being clear and convincing evidence, you've now just made that proceeding much more expensive. It's not going to be the situation where it is now, where you file a petition, patent owner responds, and then the board institutes, and then there's one deposition on each side, papers are filed and submitted, there's an oral argument, and you're done. When you've got clear and convincing evidence as your standard, you need much more proof, much more evidence. And now we're turning the PTAB into almost like it's as if you were in district court. There almost isn't a benefit to going to the PTAB other than the fact you're going to be, you know, your proceeding is going to be adjudicated by 3 ALJs instead of a jury or at a bench trial. So that would be an incredibly onerous thing to change if we had increased the burden of proof to clear and convincing evidence as opposed to what it is now. Because even now, what's the success rate for an IPR is like 60%. you make it clear and convincing evidence, it's going to drop on the other side of 50%. I can guarantee that.
Thank you. Thank you all so much. As you know, like we could keep going on about this for a long time. So I want to thank all of our panelists. Thank you so much for telling your stories and taking the time. Thank you to everyone who's been here. But there is so much more to say. If anyone wants to follow up or has any questions, any suggestions, anything, I'm Alex at PIPLIUS.org, and I'll write that quickly in the chat. Please do feel free to reach out, and all comments and all feedback is welcome. And again, thank you all so very much for your time. I hope everyone has wonderful weekends.
Thank you, Alex.
Thank you.